Hello, my name's Alistair McIntosh, Chief Executive of the Housing Quality Network. We're here today to talk about Kids Company, which has been in the news quite a lot recently. I'm joined by Kirsty Thompson and Andrew Cowan, both governance experts from Devonshires, the leading legal firm. Why are we talking about Kids Company? Well, a couple of years ago, under the Cameron government, Kids Company was delivering services to vulnerable and troubled young people. Their flamboyant, if I can put it like that, chief executive was the poster woman, the figurehead for big society. Everything was going well. And then all of a sudden, in the midst of wrongful accusations of sexual misconduct, the company ran out of friends, ran out of money. It was then subject to investigations by the House of Commons, the National Audit Office, heavily criticised Kids Company and all who sailed in her. It became the classic case study for poor governance at every conference. And then earlier this month, almost like a bombshell, with a High Court judgment in relation to an attempt by the official receiver to get the directors and the chief executive banned or disqualified. And that High Court judgment instead lavished praise on the directors. What's happened? Are there any lessons for housing? That's why I've asked our friends from Devonshires along, just so we can get to grips with some of the practical lessons from this case. So if I may, I'm going to ask my first question to Andrew and Kirsty, and it's just to clarify things. What on earth has gone on here, and what do you think the key points in the judgment are for us in housing and for the world more generally?
So I think the first thing to note is that this case was about directors' disqualification.
Yeah.
It wasn't about had they acted properly. It was had they acted inappropriately. And it came on after some time ago, the National Audit Office report and parliamentary review. And the two things are very different. The NAO report was about protection of public money. So it was looking at it from the government's perspective. And you can see if the government pumped a lot of money into an organisation that failed, that they're not going to be very happy about that. But this one was looking at it from the Kids Company's perspective. So in the context of the case that came before the courts, the question was, should the directors be disqualified? And the judgment is very clear that they should not. And I think it's the reasons that lie behind that judgment that are important here. I'm afraid this isn't the last that we're all going to hear about it, because there is a Charity Commission inquiry to follow. So it's going to be quite interesting to see how the Charity Commission take on board what the court has said, particularly because some of it does not necessarily fit well with the Charity Commission's own standards.
Kirsty, have you anything to add to that? Any other insights?
I think the other element of the judgment that's interesting is in relation to the position of the CEO and whether actually she counted as a trustee for these purposes and therefore capable of being disqualified, or was she distinct and separate from the rest of the board of trustees? And what the court judgment has been clear on in that case is that she was CEO, executive, not a trustee, and therefore not capable of being disqualified.
Okay, thanks for that, Kirsty. Next question. Does this case tell us anything new about what directors and chief executives should be doing? Or does it just remind us of some of the rules we might have forgotten along the way?
So I don't think it tells us anything new, but it does remind us about the model, about what board members should be doing. I think it's worth just remembering here what the Kids Company model was. And I think the phrase that keeps coming up was it was demand-led.
Yeah.
What that meant was it had an inspirational and entrepreneurial chief exec who was able to go out and raise funds, and they spent it as quickly as they raised it. In fact, they were entering into commitments before they'd necessarily, it could be said they were entering into commitments before they'd raised the money. Yeah. And that was part of their success. And so for non-exec board members in particular, that is a difficult one to match. So whilst the case doesn't tell us anything new about what board members should be doing, it does give us some pretty useful reminders about what is expected of them. For example, particularly, I think the fact that the law does not distinguish between executive and non-executive board members, but that in this case there was a there was a clarification, if you like, at least about the expectations of the law and the differentiation between an executive and a non-executive in that sense.
Yeah, good stuff. Kirsty, have you any points on this one?
Yeah, I think I'd echo what Andrew says. It doesn't really tell us anything new, but it does remind, and particularly I guess the focus that I would pick out is that it reminds trustees about their management of CEOs and what that relationship should be between the board and the CEO, and making sure that that's operating as it should be, and that essentially the CEO is doing what the board is asking them to do within whatever the scope of their particular delegated authority is.
Yeah, no, I think there's a really interesting distinction here as well between the law as it applies to the roles and responsibilities of board members and the regulatory, the social housing regulatory environment, those expectations. Because as far as the law is concerned, there is established case law which tells us very clearly that the courts will not examine whether a decision was right with the benefit of hindsight. What they will look at is whether when the trustees made a decision, it was within a range of reasonable decisions that they could have made. Whether those decisions end up being wrong is to a certain extent not relevant to the culpability of board members, whilst the regulator of social housing will look at it and decide whether actually, even though it was within a range of decisions that could have been made, whether or not that was a good use of public money, if you like, again, and therefore it's a much harsher judgment, if you like. And so I think that would be quite useful. You know, in the past, we've had issues where the role of board members has been called into question, and investigations carried out about the culpability of board members. And I think this is a really useful case for understanding how the courts would view it, which is very different. And in that context, worth noting what the rules of a standard community benefit society say about that, in that they do exonerate behaviour other than in the case of gross negligence, which is a high bar to reach.
I was very struck by the way they distinguish between the roles of the non-execs and the execs in this particular case. I just wondered, any thoughts on the roles of non-execs and the reliance they can place on chief executives? Because it was all, and the judgment's almost as if it was all over to the chief executive, and the non-execs didn't have to crawl over every line of every spreadsheet. And sometimes when you look at decisions in the regulator for housing space, they do set a very, very high bar for the knowledge and awareness of the non-execs, don't they?
I think here, regulation and the law sit in the same place. And that is that the role of the non-executive directors is at a higher strategic level. And therefore they are entitled to rely on the information that they receive from their executive officers, unless there's something glaringly there. That isn't to say that they shouldn't be questioning that information, and that the NatFed Code of Governance sets out some good pointers as to how that should happen, and ensuring that the right controls are in place. But that beyond that, board members are entitled to rely on the information they receive from their executive team.
I think the other thing that comes out of the judgment in this regard is about the scope of that delegation, and being clear about what actually has been delegated and what executive officers can do within their frame of reference and what belongs to the board. And I think also being clear about who in the executive is responsible for what, because there was some discussion around what actually was the CEO responsible for in terms of her figures and finances, etc., and what were other people responsible for. So I think it's the thing is a takeaway there in terms of being clear about what delegations are and where they sit.
And I think there's another bit there, isn't there, about, this has come up in problem cases within the sector, is that boards receive what in hindsight was piecemeal information, which is only when you were able to aggregate it that you could actually understand the decision that they were being asked to take. And I think board members are entitled to ask for high quality information. And that doesn't mean that sending them 1,000 pages is high quality information. Board members are entitled to receive good summaries of the matter in question. they're not expected to go through all the contracts that underlie that.
When I was reading the judgment, and I'm no lawyer, of course, it struck me that the judge was saying, because these people are volunteers and or they're low paid, you've got to dampen down your expectations of them. Just some thoughts on that. And also, flip side of the coin, if we were to pay non-executives a lot more money, would that make their level of responsibility higher? Does the opposite apply?
Yeah, I mean, I think certainly within the sector, everybody would recognise that there's been a gradual increase in the amount of fees being paid to board members for various reasons, in terms of trying to introduce out of sector experience, bring in kind of commercial and financial experience from elsewhere, and kind of needing to be seen to be able to pay to procure that level of support. And there is reference, you're right, in the judgment to the fact that these trustees were volunteers who weren't being paid at all for their services, as opposed to obviously in the sector where the majority are now paid at least some amount. And I guess, yeah, with payment comes that kind of professionalisation of services and of board membership. And if you like, it kind of comes back to the regulatory standard around value for money. The more you're paying in terms of fees, the more you're expecting from board members in terms of the professionalism and the services that they are providing. But I think it's very difficult to say that above being paid above X pounds means you owe this level of duty, and below X pounds means you owe that level of duty, because how would you possibly decide where that line sat?
Yeah, I think it's fair to say at the current NatFed recommended levels of remuneration, or sector norm levels of remuneration, this isn't intended to be a salary. It's intended to recognise, at least in part, the time commitment required, but without attempting to make a full recompense for that. And I think it's that point that it's not a full recompense, but it is establishing a bond. So it would be, I agree with Kirsty that it does establish a slight difference to duty of care, but I don't believe it would have led to any difference in the judgment of the courts on this case, even had they been paid at the NatFed levels.
If you look at all the publicity about the chief executive and Kids Company over the years, it's almost like a rerun of Arthur Miller's The Crucible, isn't it? And now we discover that actually they were doing good. They're fantastic people. The judge commended them to other organisations. Thinking about housing, and without naming names, are we sometimes too quick to leap on a bandwagon and condemn people, or are we sometimes too slow to spot and call out wrongdoing? So any reflections on that?
I think the first thing, we haven't talked about this, but it comes up very frequently, both with charities and in social housing, and that is reputational management.
Yeah.
And I can't emphasize enough how fundamental it was in this case, not least because it brought the organisation down, because as soon as the allegations were made, even though they were false, all the funders fled for the hills.
Yeah.
The second thing I think is that any regulator, and I would include here the Charity Commission, will act to protect what they regard as the wider reputation required for their sector to operate effectively, and for charities to be seen as effective agents that can deliver their charitable objectives.
Kirsty, have you got some points on this one?
I think the only thing I'd add is just from the context of the employment advice I also give alongside the governance advice, is that very often I am talking to clients about looking at that bigger picture. So there may be concerns with an individual or on a board or on an executive team, and yes, maybe you could manage them and deal with them kind of properly through process, but that overriding bigger picture about the reputation and what happens if this develops and goes wrong does tend to lead organisations in the sector to act and to prevent that potential scenario from arising.
I think one thing that's useful here, and I think boards should be mindful of, is the importance of board minutes, because that will show the debate, the discussion that was held, and the engagement of the board. The one thing that we haven't said the board are exonerated from, and is essential, is that the board members have read and understood the papers that they have received, and are then able to discuss the outcomes and reach a conclusion. That doesn't need to be a universal conclusion, but the board should act in a collaborative way, and by majority decision reach a conclusion. That doesn't mean that if you disagree with that conclusion, you should not vote. You are just as responsible whether or not you vote. And in fact, if you don't vote, that is probably your worst case scenario in terms of your responsibilities.
If we can just turn to Kirsty now with the last question. You deal with the investigations for Devonshires, and you must have looked at the whistleblowing aspects of this judgment with great interest, because yes, we need whistleblowing as a safety valve, but sometimes whistleblowing can get it wrong. Any thoughts on whistleblowing in this case and more widely in the sector?
Yeah, I mean, the whistleblowing angle here is that concerns were raised by several members of senior staff of Kids Company who'd left before things went really bad, and they relied upon a lot by the official receiver in the judgment in terms of the evidence that they were bringing about the concerns that they'd had, and whether they were being addressed properly, and whether they were being told that they shouldn't be escalating concerns to the board, and whether the board, in fact, when they were attempting to raise things, were turning around and saying, no, don't tell us about these things. And obviously whistleblowing is a fundamentally important area, and all organisations should have something in place which properly, so not just a piece of paper that says this is our whistleblowing procedure and this is what you can do about it, but actually genuine commitment to whistleblowing, so that any issues and concerns that are identified and can be addressed accordingly. So yeah, it does provide that safety valve function. And I think within the sector, there is a broad commitment and understanding to whistleblowing policies and procedures, and you see particular board members being designated with a responsibility for that as kind of the ultimate person within the organisation, and a kind of a detour route that you can go to the top level if there's something blocking a disclosure being made in between, or concerns being raised. But I think there is something to the point around, yes, sometimes concerns will be raised that are unproven or untrue, and fundamentally what whistleblowing legislation and the principles are about is people who have a reasonable belief that what they're disclosing is true. So they're not actually required to prove that what their concerns are made out. Their only expectation is to have a reasonable belief in what they're disclosing, and then it's for the organisation to investigate and identify if there is in fact that concern, and if there is, to address it accordingly.
Good stuff. Well, listen, I'd really like to thank both of you for giving up your time. You've gone through a very lengthy judgment, very succinct remarks you've made. You've made it ever so relevant to housing. So thanks from everyone at HQN, and I wish you well for the rest of what I hope is a much shorter lockdown than we might be expecting. Thanks very much.
Thank you.
Thank you, Alistair.